Hi, my name is John Sivertson. I'm currently a land supervisor at Chesapeake Energy Corporation, working in the Powder River asset, the western U.S., but primarily the Wyoming asset that we have. Here today to talk about federal units and horizontal development. That's what it was titled. I should have been more clear that it's federal exploratory units. There's a lot of different ways to unitize and use federal regulations, the Mineral Leasing Act of 1920. To produce and manage oil and gas properties. A little bit more about myself, other than the bio. Had the opportunity, I've been working full time as a landman since 2008. And I've had the opportunity to work multiple assets in Texas, Permian, Eagle Ford, East Texas, as well as Louisiana, the Haynesville primarily, Ohio, the Utica, and worked the Powder River Basin multiple times for Chesapeake and currently there. Just wanted to say I have a great appreciation for lease and title analyst. Early on in my career, didn't know a whole lot about kind of what that role was, but I left for a couple years to go to a PE shop in Houston, a much smaller organization, and really my appreciation for everything and the value of what you do has just grown exponentially since then. There's a lot of power in the data, the accuracy of the data, and so thank you for that. We have about 20 slides to cover here in about 45 minutes. There's, to understand federal units, a lot of the initial conversation will be history and kind of how to form these. But I hope that to make it relative, especially if you haven't had the chance to work federal lands or federal units, and try to relate back to some of the assets. I'm assuming most have worked in Oklahoma, New Mexico, Texas, and other areas. My email address is there on the screen. I know we don't have an opportunity for in-person Q&A, but feel free to email me. I'm happy to answer any questions that you might have after this presentation. Chesapeake's in a unique position. We were one of the first operators to have large-scale horizontal development in a federal unit. There's multiple other operators doing the same these days, a couple of them local here to Oklahoma City, a couple in Tulsa, and obviously, as you would expect, several out of Denver and other parts of the country. I'm going to talk about the formation and the contraction of participating areas, or what we would refer to as a drilling and spacing unit in other areas. Kind of some of the lessons we've learned, the do's and don'ts, and really focus on development as far as unconventional plays are concerned with the shales, the shale revolution of the last 10 to 15 years. Again, like I said, this will be a discussion on development in federal exploratory units. I should have been more clear again entitling this for the purposes of the OCapitola seminars next week on the 22nd. Again, not meant to be a step-by-step guide to creating federal units. We could talk about that for days. But again, we will kind of talk about the history of them in the administration of the federal units. So again, my email's on the first page there, and I'll have that on the Q&A slide at the end. So the purpose of a federal unit, just in general, not just federal exploratory units, but also secondary units and things of that sort, is to regulate and prevent waste. Certainly terminology we're used to when we deal with conservation and commissions and regulatory environments. Promote logical development and the conservation of resources. And then as an operator, it allows for strategic exploration and development. You're allowed to put together large pieces of land, which is especially valuable when you're in remote areas where, capital intensive environments to produce oil and gas or to explore for oil and gas. And then also as working interest owners, it allows you to spread your risk and expense. And then a couple notes too that I didn't put on the slide, but for those familiar with federal lands and the ownership of federal leases, there's chargeability limits that any one company can own in a given state, and by forming a federal unit, the chargeability is eliminated, or at least those lands are eliminated from your chargeability count. And then lastly, in many cases, not all the time, but you can almost ignore state spacing requirements or statewide field rules or spacing rules to allow for optimal development based on your subsurface science. So a little bit about the history of federal units. It's widely regarded that the first federal unit was the North Dome Kettleman Hills Field in California back in the late 20s. It's in the San Joaquin Basin there. There's a lot of different anticline type fields that were produced there historically, and some are producing. Dr. George Smith was the director of the U.S. Geological Survey, and what had happened was we found a lot of new uses as a country for oil, and there was a rush to produce as much oil as possible to feed the need, and it led to excessive drilling and waste. If you've ever seen pictures of some of the old oil fields, say in Kilgore, Texas, where there's derricks just lined up down the street, you produce the oil and gas, it eliminates the gas cap, and it causes a lot of waste of oil in place in the ground. And the Mineral Leasing Act of 1920 didn't contemplate the concept of unitization. And so Dr. George Smith, prior to Congress enacting some amendments to the Mineral Leasing Act, had worked with the owners of those leases to conserve it, basically, to be smart with the production. And he actually shut down, or had them agree to shutting down production through 1931 just to get everything under control. The Secretary of the Interior was granted authority by Congress, and they amended the Mineral Leasing Act to allow for, and you can read it here, the conserving of the natural resources. So basically being able to form field-wide unit plans or cooperative agreements to make sure that the most resource was coming out of the ground. And then there's been various amendments to the Mineral Leasing Act over the years, and we'll talk about a few of those on the next slide. So here's a little bit about the history. There's many more amendments to this act. There's lots of different moving parts to just federal leases in general, not to mention unitization. But a couple important ones that we should be aware of and remember as we even populate federal leases into our various systems as an oil and gas company or as an oil and gas business. Things to be aware of that should happen or could happen with federal leases in general. So in 1946, the BLM were granted the authority to direct the rate of exploration and development and the quantity and rate of production. So much like a Oklahoma Oil and Gas Corporation Commission, Texas Railroad Commission, and other similar bodies, the federal government has their own. And so this allowed for the extension of leases for the life of a unit, assuming you met unit obligations. Communitization agreements, something I'm sure most are familiar with if you've ever worked with federal lands, producing federal lands, those were authorized. And we'll talk a little bit more about leases and how you extend and segregate leases as we move through the presentation. And then of note, 1954, extension of production for leases already in their extended term. So say there was leases already producing that were segregated, and we'll talk a little bit more about that down in a few slides. It basically gave clarity to operators and to the BLM about how to treat federal leases. And of importance to operators is in 1987, effective in 88, the public interest clause was introduced, and we'll talk about that also further into the presentation. So how they work, and I put a note on the bottom here, full disclosure, the teapot dome, this is meant just to be a reference to show geological structure, not a federal unit, and is typically driven by geologic evidence. It can be up to 25,000 acres, so if we do the math on that, a standard section in the Jeffersonian system of a mile by a mile, you could have up to, let's say 39 sections that could be held by federal unit operations. Typically all depths are unitized unless they're excluded, and really what it causes is you to have one big lease, assuming you meet the guidelines of the federal unit agreement. So it makes it very optimal for operators to develop, to drill a single well to test and make sure, for the really that they're able to protect their sides and not get into a competitive environment that may kill economics on the field. And this is similar to field-wide units, and you're going to notice a lot of similarities through the presentation, but there are some differences in how federal units work versus a field-wide voluntary unit or a water flood unit that you might see in other states such as Oklahoma or Texas. And if anybody's interested, there's a lot of history on that teapot dome. And I might share a story here at the end if we have a little time. So federal exploratory unit TRACT status. There's 4 different types of TRACT statuses, and I won't read these verbatim. But at the end of the day, what you need to know is to participate in the federal unit and to reap the rewards, operators really need to get all the TRACTs either fully committed or effectively committed. Effectively meaning 100% of the working interest owners and record title owners, as well as the royalty owners. To be able to form a federal unit and have it operate under the terms of the federal unit agreement and the federal unit operating agreement. And fully committed, really the difference in that and effectively is if you have overrides or other burdening interest on the leases, also ratify the federal unit. Federal, state, and fee leases, you can join all of them. Typically, it's a minimum of 10% of federal minerals or federal leasehold that needs to be part of the unit. But also to form the unit, you need 85% of the unit area on a tract basis to be committed. And what that means is you need 100% commitment of the tract, not just 85% of the unit leased and committed to the federal unit. So you have to be careful there. If you have undivided leases or undivided unleased owners in a tract, you wouldn't be able to count those towards that 85%. And I threw a note in here just in case you're ever doing due diligence or reviewing a federal unit agreement. Just for ease of reference, a lot of times those exhibits can be dozens of pages long. Federal leases are typically listed in chronological order, so that'll help you, that'll be easier to find them. And then fee leases are typically ranked or listed in by their legal description. So I'm hoping anybody out there that has a 100-page federal unit exhibit in front of them that could, help them get to what they're looking for quickly. Classification of ownership. So there's lessees of record, which are all parties owning the record title. For those that haven't ever worked with federal leases, there's two different types of ownership of a federal lease. There's lessees of record, or the record title interest, which is the name the BLM will have assigned to the leased. The responsibilities of those parties, what I boil down to is they're the parties that are going to be noticed. They're the parties that are responsible for the rental or making sure any rentals or fees or fines are paid. And also, and something we're seeing a part of, and this is just a tidbit to anybody out there, is when you own the record title, let's say all the other parties that are record title go bankrupt and you're the party holding the record title, even if you don't own any production on the lease or operating rights, the feds will ask you to P&A the well. We've had a couple recent instances of that, and I would just encourage everybody that's aware of that situation to, I guess in some sense, if you have no reason to hold record title, make sure that the parties who operate the wells retain that so you're not liable for the plugging of the well. Working interest owner is a common term. We're very used to that. And those, parties owning the operating rights. So you can own operating rights and not record title in a federal lease, which means you have the actual right to develop the property, to drill, develop, produce the property. So for those that haven't worked, there's two unique sets of ownership and they do differ. So be cautious of that. There's the least basic royalty interest, which again is just the royalty owner. The unleased, same concept, and then there's overrides, which everybody's familiar with. So fee leases in federal units, there's definitely some things to be aware of with fee leases. You may think, as a fee lease owner, why would I ever join to a federal unit? That's a great question, and a lot of people are asking that question, especially in this era, 2020. But for a long time, in certain states like Utah, Nevada, 80-85% of those states are federal mineral ownership, and there's really not a way to produce or develop fee ownership without federal lands, which have their own sets of criteria, especially on the regulatory side these days with environmental concerns primarily. So how fee leases are joined is they can be forced joined by the provision. So I remember early on in my career, I always wondered why there was a pooling provision in the lease and a unitization provision in the lease. They seem to do the same thing to me. But what that does provide for you to do is either you can force join leases that have unitization provisions to a federal unit as the operator, as the lessee of that lease. And if there are restrictions in the lease, or say there's an express written consent provision to unitize, you can have those parties execute a ratification and join to the federal unit, which is really just a one-page document, standard ratification saying, I hereby agree to join the federal unit and have my lease modified to meet the conditions of the federal unit. So what a joinder can do, and I won't go through an entire lease and every provision impacted, it does impact your term. So say I form a federal unit in 2010 and my fee lease is set to expire in 2011. We'll get more into the timing of federal units, but essentially the term of your lease is joined until that federal unit contracts or is terminated. It controls the rate of exploration and development and also operations and production. So say your cessation of production clause or operations clause, or there's other timing restrictions or obligations in a lease, those are modified by the federal unit agreement to meet what the unit agreement says. Things that aren't modified, however, are royalty. You'll get your royalty. Let's say you have a, even if you have a deduct none, deduct all type clause, it won't modify that one bit. It won't amend the ability to assign and some of those other kind of covenants or express written pieces of a lease. And the other thing I made a note of and didn't put on this slide, I was thinking about it this morning, is it won't modify any surface restrictions or the need to enter into a surface use agreement with an owner. So some rights are retained, but really the rights that are conveyed or modified by the federal unit is the ability to develop and produce the property. And you also may provide consideration. There are leases out there where there's no consideration provided for, and those leases are held by any operations in the federal unit as long as you're meeting those obligations. But a lot of times what you'll enter into, and there's an example on the screen here, is what we at Chesapeake have called a non-PA rental. I think that's pretty consistent across the industry, but it's an annual rental or delay rental in some sense in lieu of production, and we pay that once the primary term of that lease expires to compensate the owners for holding the acreage for development purposes. So in this case, we've, lands that aren't in a producing unit, a participating area, and we'll discuss the definition of that, will be $50 an acre a year to retain that leasehold in the federal unit. So federal leases in a federal exploratory unit, and there's going to be a lot of moving parts. My hope is that a lot of people have worked with federal leases. That's kind of its own other topic and can be its own 45-minute discussion or presentation. So we'll touch on a few items here. The Secretary of the Interior, their authorized officer, are allowed to join federal leases to a federal unit. They're also allowed, obviously, to form the federal units. Lease extensions and unitization, that's important, especially when you're going to set these leases up, or if you have leases set up as you divide them out into their respective statuses. There's extensions by drilling. So on federal leases, the Leasing Act of 1920 grants a 2-year extension on any lease where actual drilling operations are being conducted over the primary term. And so if you meet the obligations of the federal units, you drill the initial well, you meet the public interest clause, which we'll talk about here in a couple slides. You've saved those leases. Essentially, you have one big federal lease for operations while the federal unit is in place. Extension by production, I think that's a given. If you drill and produce any lease, it's held by production. As long as that well is capable of producing and paying quantities on a lease basis. And there's extensions by segregation, which I think is the most important one, especially when you're forming a federal unit. So let's say you have a 1,280 acre lease in sections 1 and 12. Section 1 gets committed to a federal unit. Section 12 is outside the federal unit. That lease will be segregated into 2 separate leases, one to be held by the federal unit and one not. And so your term, you've essentially created 2 new leases and need to manage them appropriately or accordingly as 2 separate leases. There are instances where, say you have an old 1960s federal lease, obviously it would have production since it's 2020 today. And, if you say that lease is part in out of a federal unit, the lease, while it may be segregated, will still continue to maintain that HBP status as long as there's production or you're otherwise compensating for the lease. But there is a chance that you'd owe a rental if the land's outside the federal unit or non-producing, and that's that sub-bullet down there where it says rental may be owed. You may actually owe a rental on the lands that were segregated out of the lease, but you will continue to hold that lease. And then this is just a little note here, but if the public interest requirement is not met, which we'll talk about, all the lease extensions would be voided and would revert back to their original expiration date unless they were otherwise held by production. And one thing I didn't mention on the previous slide, but it's just a quick note. Some may be wondering, why didn't we talk about state leases? That differs by state, and so just be aware of how your state treats state leases that may be joined or segregated by a federal unit outline. There's 2 types of federal units. There's undivided, and essentially this is just a big, let's just say it was 25,000 acres. You have 25,000 acres held, and all the working interest owners in that federal unit would have the same working interest in NRI across all lands. So even though Company A may only own a section on the east side, you would obviously dilute their interest, and they would have ownership in the entire unit and any activity that happens in that unit. There's the divided type, which is more common. Cost and revenues, working interest are based on the drill block or participating area. So essentially only the owners that own the leasehold that's part of your proposed well and participating area or drill block would participate in the drilling, completion, and production of those wells. Though all other owners that might be outside of that drill block, they have the benefits of the federal unit, but they wouldn't have any rights to that well. And so that's definitely the more common form that's used out there. There are a couple hybrids out there between the undivided and divided, but I'm not aware of any. So while there is that chance, they're not very prevalent. And I guess if you come across one of those, just make sure you understand what the hybrid is, what the differences or the joinder of the two units is. There's two different things that you execute to operate in a federal unit. There's the unit agreement, and without being able to show everybody that or spend a couple hours on it, what I can really boil it down to, it's an agreement not with the federal government or the BLM, but essentially it's like a development agreement or a participating agreement, in that it'll designate who the operator is going to be, what their rights and obligations are, how expense and production will be allocated, the rate of development. So it's an agreement as to how you're going to develop the lands, rather than an operating agreement that governs well-specific drilling, completion, and production. There's a unit operating agreement, which would be, it's the federal form of our standard AAPL model, 89, 82, all those different forms that we have out there. And what that will do is obviously govern the development of exploratory wells and development wells. It talks about the apportionment of cost and ownership, the disposition of the property, and various other provisions that you would see in more of a private JOA or an AAPL form JOA between two parties. And what's very important there is it also establishes how you revise and consolidate participating areas. And we'll have some visuals here in a couple of slides to kind of show everybody or demonstrate to everybody what that looks like. And I think what's important too and why I say that the establishment, revision, and consolidation of participating areas is important is oftentimes you will form a drill block which you think that you'll produce from your well. By the time it's all said and done, it will likely change, and your ownership and the status of some leases may change in that participating area. And we'll talk a little bit more about the formation here in a couple slides. So I've mentioned multiple times that we talk about the public interest requirement, which is critical for operators to understand. Basically, once you've formed a federal unit and it has an effective date, you have 6 months to commence operations. And this is diligent operations for the development of oil and gas wells, not going and putting a shovel in the sand and trying to perpetuate the leases. This is diligent operations. This is filing for permits. This is building locations. This is the actual drilling of a well capable of getting to the target depth. So it's very important that operators be prepared to dive in once a federal unit is formed. If they don't, or they fail to perform on the public interest requirement, your federal unit is terminated, and any kind of benefits you might have gotten to your federal leases would also be void. So any kind of extensions and anything of that sort would be done. Operator must continue to commence operations on subsequent wells until a well capable of producing and paying quantities is drilled. What's important here to understand is under the federal unit agreement, the production and paying quantities is defined as production sufficient to recover the cost of drilling, completing, producing, and operating the well. So if you have a $10 million well, you need to be able to prove that you're going to produce $10,001 in revenue out of that well for it to qualify and to be able to form a participating area. Federal lease level, we're going to get into federal leases a little more, but for a federal lease, the definition of production and paying quantities is production sufficient to cover operating expense and royalties. So essentially your LOE and royalties, and then it would be held. And that leads us to the Yates well discussion. So we all know that the chances of drilling a barn burner well or a PPQ well is risky, especially if you're in a geologic prospect that's really never been developed or explored. And so if you drill a well that produces, but it's not capable of meeting the unit agreement PPQ analysis, it does benefit the operator. It will extend unitized and committed leases since it isn't paying quantity. So you've gone in 6 months, you've drilled a well, it does produce. It will extend all the federal leases in the federal unit because you've drilled a well capable of producing and paying quantities, assuming that well covers operating expense and royalty. What it does not do is satisfies the public interest requirement, but you will still need to continuously develop every 6 months, commence operations on another well, and that date can differ. It can be 90 days, 6 months. You can work with the BLM to modify that depending on conditions in the field, but you will need to continue to drill wells until you've drilled a well capable of the definition in the second bullet there. Production and paying quantities. So paying well determination, if a well is determined of being capable of meeting that PPQ or production paying quantities criteria earlier, that you'll submit well, either way you'll submit the data to the BLM. At that point the BLM will evaluate the data. They oftentimes in our experience have wanted at least 3 months of data. A lot of times they may want 6, 9, 12 months of data or production data to be able to determine whether or not the well is capable of producing and paying quantities and recouping drilling and completion expense. If it does determine that it does meet that, if it does meet that criteria, the BLM will form a PA, which is effective on the completion date of that well. A participating area, it's the same thing as you would call, let's say, a DSU, a drilling and spacing unit, a pooled unit, anything else you might call it in the states that you're working in. It's the same thing as forming a pool for that well, with appropriate setbacks, production, allocation, all those other measures that most would be familiar with. And then there's the participating area. I'll let you read the definition here, but it's essentially what I've just described. So we'll refer to that as a participating area going forward, but keep in mind it's just like a spacing unit or a pooled unit in a voluntary state. So now we finally got some visual. I think we haven't had a visual since the teapot dome there at the beginning. And obviously email me with any questions you might have, but this is an example of a drill block for a federal unit well. You can see that in this case, those are 10-acre blocks, which can make for I'm sure, a tracting nightmare when it comes to entering this data into any system. But this is a typical radial drainage area formed for a proposed well that you would submit as your paying well determination. So radial drainage area is a widely accepted form for determining the area around which a well will produce. Even if this was just a vertical well, a lot of times, you'll see the radial drainage area being equivalent to, let's just say, a 40, like what we'd see in other states, like a Texas or Oklahoma. You could see a 40-acre allocation unit or maybe a 160-acre spacing unit. And in some of these unconventional plays, at least how it's been established with the field office in Casper, Wyoming, is a 745-foot, circle or oval, a radial drainage area around this well. There's really no regulation on size. The operator in BLM will determine that based on science or the best science that they have available when they establish the federal unit. Typically, these are drawn in a fashion that is, as long as it captures a 50% of a quarter or a 40-acre block, it would be added to this drill block or to this participating area. However, I've cited a case there back in '87 that where it's possible to reduce blocks by legally described blocks down to 10 acres, you would do so, and this is an example of that. It is on a surface acreage basis, but only committed tracts are entitled to production. We'll talk a little bit about an example in a few slides about what you would do with an uncommitted tract, somebody who hadn't joined the federal unit. But it is on a surface basis, and you could cut committed tracts out, just like you'd say cut out an NPRI owner in Texas or another state. And in some states, like in New Mexico, the BLM will follow state spacing units. I haven't worked in New Mexico, but I've heard that essentially all the wells that are being drilled now on federal lands in the Permian, it's really just stand-up 160s, or if it covers 2 sections, then it might be a stand-up 320. And so essentially the state of New Mexico and the BLM agree on what the spacing units would be. And forgive me if I misspoke. This is just in discussions with other friends in the industry that have or are working in New Mexico in certain areas. So participating areas in federal units. So here's an example of operator has gone in and drilled multiple wells. you can see that there's 3 different radial blocks that have been drilled around these 3 wells. And just to note, I'm going to use this visual for 2 different examples, both for an expanded PA as well as development of uncommitted lands. We'll use this gray area down here in the bottom right, the furthest east well there, to talk about what you would do in that situation. So operator has drilled, proven these wells to be capable of producing and paying quantities, capable of recouping drilling and completion costs. And so you apply for an expansion of a participating area that's established. So let's just, for instance, use the westernmost well as the well that you saw on the previous slide as the initial well. So we drilled that well, we've gone in and drilled this middle well here, and we've gone in and drilled the 3rd well, and we've proven that they're all producing from a common reservoir. What we'll do is a very widely accepted and most often used circle tangent method, which provides that basically you've connected the dots, you've proven that it's a common pool, and all lands on both the periphery of these eastern and western wells, and all lands in between would be joined to the federal unit or to the participating area for that zone. And so you'll note that all of a sudden you're bringing in all these lands that you didn't think were going to be part of your participating area or your drilling and spacing unit. So the status of all of these lands would also change from maybe held by federal unit to now HBP, because they will receive production from the 3 wells. As the expansion occurs, you present evidence to the BLM. In our experience, they'll usually sit on it a while. They like to make sure they have all the information that they can have available before they approve this. But then it will become effective the first of the month in which the evidence was provided. So say the BLM waits for a year or wants production for a year before they'll approve this. That's a lot of uncertainty, and I know that if there's anybody with division order accounting experience, or really anybody in the land profession, this can drive you nuts, because do you pay, do you not pay, how do you pay, what's held, what's not? It can be a real administrative, I don't want to call it a nightmare, but very frustrating to a land professional. Moving on to the second example of an uncommitted tract. So this gray area in the south part of this eastern lateral here, let's just say that owner did not commit to the federal unit. Well, 2 things could happen. One would be, it's unlikely you would join it to a participating area because you've penetrated minerals that aren't committed to a federal unit. What you would do there in most any state would be, essentially, while you're in the federal unit and some of these committed lands reap benefits and the rewards of the federal unit, you would actually have to go in front of your state body and file for a spacing for that well, at which time you would form a communitization agreement, which would be separate from the participating area. And so, obviously it's very important to get all the lands committed and try to develop on committed lands to get the benefits of the participating area, should you be able to form one. And I put a question here about overlap. This is kind of its own discussion, but let's just say you've submitted for a 745-foot circle tangent around your well, and as your understanding of the reservoir progresses, as you learn more about the reservoir, all of a sudden you see that you need 3,000-foot spacing between wells because you're overproducing the reservoir. There's communication between the wells. What could happen in that situation is you might form a CA that the participating area overlaps, and we've seen a few instances of this. So then it's the question of, do you double pay the royalty owners in that that quarter call, or how do you treat that? I don't have a 100% answer today, but it's something to be aware of, as you may run into overlap situation in an unconventional development inside a federal unit. And apologies for this last bullet here. I've just already talked about it and kind of addressed it up in the other bullets, of how to treat uncommitted lands. So it's a very unique circumstance. We try to avoid it, but the other reason that you would need to form a spacing unit is if the well is not, I'm jumping back up here a few bullets, my apologies. If the well is determined not to be capable of producing and paying quantities, it would not obviously qualify for the PA, and you would also need to file for a spacing and then submit a communitization agreement for those lands. So a lot of moving parts, a lot to manage. You just hope that all your wells meet the PPQ analysis. I really want to talk about kind of how this impacts, we've been talking about it as we move through the presentation, but how it impacts a lease and title analyst. So finishing out a federal unit, you've got, once you've met the once you've drilled a well capable of producing in paying quantities, you have 5 years where you don't have to do anything. So during that 5 years, you can do a lot of science, you can continue to drill and produce, you can do whatever you feel like as an operator. At the end of the 5 years, you enter into a continuous development phase, and the way you'll read most material now is you have to drill or commence operations on a new well every 90 days, but the authorized officer does have the authority to amend that to, let's say, 2 wells a year, and it'll meet the requirement for continuous development. All leases are joined, as we've talked about, to the federal unit until the federal unit terminates. And another thing that's important if you're in a stack pay situation is, each zone or each formation that you're producing has to have its own PA. So you might drill, let's say, a Niobrara well and have a Sussex well overlaying it. Those have to be separate PAs. They can't be in the same PA for production purposes. So how does this affect, land administration, a lease analyst, a land professional is, as you saw in those visuals, there's a lot of tracting out of leases that can occur. You could tract them out, and then those statuses could change as the PA expands or contracts in the future. And so there's a lot to monitor there, especially when you move down into 10-acre blocks. It's a lot of legal descriptions that have to be spot on. You create your exhibits and everything else you have to file. They obviously need to be accurate. They're filed with the feds or with the BLM, and also could be filed in the record. An interesting deal is when it comes to pew clauses. So a pew clause won't kick in inside a federal unit until the federal unit is terminated. But we talk about basically let me skip past that real quick and I'll come back to that. I'll talk about it on the contraction slide that's coming up next, or the slide after, before we finish out. Remember that the lease provisions versus the unit agreement, the unit operating agreement, commencement and cessation of ops, maintenance provisions such as shut-ins, rentals, other things like that, queue clauses, those are modified by the unit agreement. I'll take a step back there, and as far as maintenance provisions are concerned, it's unknown as to whether or not a shut-in would be paid. I would encourage you to look at shut-ins on a lease basis. And if it's a well-by-well shut-in, a shut-in that's owed during the primary term of the lease, there's a chance that you may owe a shut-in while the federal unit is still alive. And when it comes to lease rentals, how are they owed? When are they owed? Lease rentals are always going to be due on a federal lease until it has a producing status or a minimum royalty status, even if it's inside the federal unit. The state is the same way, or most states would be the same way. I can't think of a state why they wouldn't want their annual rental. And for fee, we talked about, in a fee situation, you could just have a unitization clause with no compensation. It's held. But if you do have a non-PA rental, you owe that on an annual basis until all or part of that lease is held by production or by a producing well. So contraction, lease status, a federal, it'll contract after 5 years. We've talked about that. The only way to really go past that additional 5 years, so a 10-year term, is if you have a well that's drilling, or if you're diligently commencing operations, continuing to develop, you may be allowed to hold a federal unit together until that well is completed and receives has been evaluated for participating area status. Fee leases would operate under their own provisions if they're producing their HBP. If they're non-producing, they terminate when the federal unit terminates, assuming they're past their primary term. We'll talk about pew clauses here in a second. Federal leases producing HBP, non-producing, when the unit terminates, you get the greater of the primary term or 2 years. So you're essentially guaranteed 2 years on federal units at contraction, but that goes back to the termination date established by the BLM. And there's no segregation of federal leases if they're partially contracted out of a unit. Typically, in my mind, that would be a situation where part of the lease is producing, and so it's held for as long as the lease produces. And state leases producing HBP, non-producing, it depends on the state. Some states like Wyoming actually give you a 2-year kicker once the unit has been terminated and that date's been established. So be cautious with state leases in whatever states you may be working in when it comes to federal units. We have 2 more slides. I know we're a little short on, I just got a couple minutes left here, maybe 5 minutes. So let's talk about contraction real quick. I've alluded to contraction, talked a little bit about contraction, throughout the last few slides. So leases and lands within a participating area continue to be subject to the unit agreement and unit operating agreement until they contract. And let's remember that every participating area formed is its own unit. So say you have a 10 well participating area, as long as you have one producing well, just like you would in a spacing unit or a voluntarily, a pooled unit in a voluntary state, those leases will continue to be held. Which can be very valuable when you have 5,000-6,000 acre block, and as it produces, you get down to a point where you can only have one well that's economic. It'll continue to hold, but you must continue to manage that entire block. Rentals may be owed. So on fee, if there's no PU clause, they're treated as HBP as to all lands covered by that lease. If there is a PU clause, this is very interesting. We just ran into this. The way the unit operating agreement, at least ours, work is each PA must be reduced to 40 acre or quarter blocks. Well, in this case, in this example you see, we formed our PA based on 10 acre blocks. So you have a lease with a PU clause, and only 20 of those acres are producing. The other 20 may be out, but because of the way the federal unit agreement works, there might be a 40 acre block held. And so you may or may not owe a delay rental on that annually to maintain that 40 acre block, since it's not 20 acres of it isn't receiving the benefit of production. If anybody wants to email me, we could talk a little bit more about that, but it's very interesting and something we've recently run into. For federal, if it's producing, it's a minimum royalty status. You need to monitor and work with the BLM and the ONRR to know whether or not you owe a rental. And non-producing, as mentioned, you get a 2-year kicker from the contraction date or until you drill a well that's capable of producing in paying quantities. And then again, on the state, just know the state that you're working in. So last slide, we'll talk a little bit about contraction, and I'll talk a little bit more about PU clauses here. What we need to know and how this impacts the provisioning of the lease or changing the status of a lease is the lease HBP or extended. And for all those reasons mentioned in previous slides, the lease could be held, but part of it could be held. You could owe a rental on part. Every year you might have to redo the math as development happens on what that rental would be. And at 10 acre blocks, it can be very time consuming to do that. We talk about PU clauses. I gave reference to the quarter, the third bullet there in the previous slide, but talking about PU clauses is, at a surface level, you would say, well, my PU clause kicks into all lands that aren't in the participating area or in a 40 acre block that's intersected by a participating area. The interesting question here, and something I don't have 100% answer to, is what happens to your PU clauses that deal with depths. Say you have a PU clause that's 100 feet below the deepest producing formation, or say you're working in an area where it's all depths that aren't producing at the end of the primary term. Do you lose those depths, or is the PU clause still modified by the unit agreement? I don't want to give you an answer either way, but if you are dealing with that situation or run into that situation, I would certainly seek legal counsel or somebody familiar with federal units and how to treat leases with a depth PU in particular. Producing leases, moving down to the second bullet there, producing leases are modified to meet the unit agreement definitions or the provisions of the unit agreement. Non-producing HB leases operate under their terms, and again, just be careful with PU clauses. And we've talked enough about how rentals are owed or when they aren't owned on Fed, state, and fee. Again, it's just important to understand what was developed, what was included in a participating area or a communitization area or a communitized area, and what may be owed or what may not be owed at any given point in time on an annual basis, especially if you have development, if you're actively drilling and producing wells. Again, my email is here. We covered a lot of ground, federal units and really just federal lands in general and how you operate on federal lands. You could have a 2-day seminar on that, and there's a lot of good ones out there. Rocky Mountain Mineral Law usually has a lot of good topics on operating with federal lands and federal leases. I know that a lot of this was history and just kind of background on what it is, an exploratory unit. But what land professionals do to create, manage, and contract federal units is very extensive. There's a lot of work where you go back on yourself to change statuses that were this, were that, and so you have to be very careful. You have to monitor very well to make sure that you're fulfilling the obligations under the unit agreement and the unit operating agreement. And with that, again, feel free to email me with any questions. Appreciate your time, and I hope that this was helpful and relative to some, who are watching this.